afternoon and good evening. These are the traditional greetings now in our webinars and other activities that span the entire globe. I'm very grateful for our partners, the IAI, the International Arbitration Institute, and the ILI, the International Law Institute, for partnering with us in putting together this webinar that is going to be very topical in the context of the reform that is being currently carried out in Working Group 3. One of the topics or the items or elements for reform that have garnered a lot of support was the setting up of an advisory center to assist developing countries in defense and in broader management of investor-state disputes. And a lot of countries have proposed or supported the inclusion of this
Norton, I'm on a webinar. Can I call you later in the morning?
Into the reform package.
No, I don't have the time. I cannot speak. I'm sorry. I'll call you later.
So we are very pleased that a group of fans or enthusiasts of the project have further picked up the topic and have worked on what is really the crux of the matter. If we want to put any of these reform options forward, is how much is it going to cost and who is going to pay for it? So this is really I find a very exciting webinar, which is going to look not only in the broader picture of what would be desirable in terms of reform, but also in what is feasible. And for that, I'm very thankful to the panelists that will present on the report. Of course, Carl Sauvant, who has been leading this effort together with Los Angeles. And Ndanga Kamau, and of course also our discussion starters, Gaston Kenfak, who's joining us from Cameroon, Charlie, who's joining us from Thailand, Natalia, who's joining us from Costa Rica, and Rebecca from the Netherlands. So with that, I would like to wish you all a very successful and enriching webinar. I give over to Carl, but not before thanking the pillar of international trade and investment disputes, John Wallace, who will be closing this very interesting event. So over to you, Carl, and with a great pleasure to listen in. Thank you very much.
Thank you very much, Anna, for your introduction and also for co-hosting this webinar together with the International Law Institute and the International Arbitration Institute. And of course, special thanks to Robert, who is bringing us all together virtually today. Good day to everyone, and thank you very much for registering for this webinar. And thank you, of course, also to the panelists for participating in this event. I don't have to introduce the panelists. Anna mentioned already all of them. In any case, their bios are contained in the program. And by the way, we are planning to have a similar webinar in French, hopefully within the next 4 weeks. Well, as Anna has mentioned, the topic of an advisory center on international investment law is on the agenda of the working group. This webinar is not meant to deal with a range of issues related to such a center. Rather, it focuses, as Anna indicated, very much on a very specific question, namely how much, given certain assumptions, it would cost to establish such a center and what could be sources of funds for this purpose. And I would kindly ask the participants and of course the panelists to stay on this focus. It's big enough for one webinar. We want to make this webinar as interactive as possible. The panelists have therefore been asked to stick to clear time limits. And at the same time, if anyone from among the participants has an observation or wants to ask a question, please use the chat box. We will be all monitoring it and respond. So without further ado, let me ask Ndanga and Nicholas to introduce the note on which the webinar is based. You all have seen the note, so Ndanga and Nicholas will just have to remind us of the most important points, and they have a total of 10 minutes for that purpose. Ndanga, I understand you are starting, so please go ahead.
Thank you very much, Carl, and thank you very much to UNCITRAL for giving us the opportunity to present our work on this really important project. As Carl says, I'll be starting off with the assumptions and the estimates that are the product of our work, and Nicolas will then come in with the budget and the sources of financing. So before I get to the assumptions and giving you a taste of the results that we got from our work, perhaps it's worth mentioning a few things. The first is that, of course, our work is focused just on the cost and not on the reasons for having an advisory center. The second is that our work focused just on treaty-based disputes, not disputes based on contracts or on investment laws. The third is that beneficiaries are states. And perhaps the most important to bear in mind as you listen to us is that these are just estimates. And while we've worked hard to ensure that our estimates are robust, these are really just estimates of what the costs would be of such a center. So with that, we made a couple of, or several general and case-related assumptions in our work, and I'll highlight a few of these. The first is the general assumptions, and on these we made assumptions based on services, beneficiaries, and human resources. Starting with the services, this center would be providing representation services on mediation and other forms of amicable settlement, representation on arbitration, but would also have a capacity building component by way of a secondment program. On the beneficiaries, these would be states, as already mentioned, and specifically developing states, as well as least developed states, with the least developed states being the focus or the priority of the work. And of course, which states qualify as developing states or LDCs would be based on the United Nations classification of states. Finally, on human resources, here we started off with an estimate of the number of staff that such a center would have, and then extrapolated that or used that to estimate how much work such a team would be able to carry out. Of course, there are different ways in which we could have carried out these estimates, but this is where we started off with our work. So we had two scenarios, one in which we had 15 lawyers and a second scenario in which we had 8 lawyers. And I'll break that down for you when we get to the point where I report on the results of our estimates. On the case-related estimates, of course, of priority here is to ensure that the center will be providing high-quality work. And this, we understand, would, of course, need to be balanced with the reach of the work. So the estimates here, again, are based on that really critical component or critical element of the work of the center, which is high-quality work with necessarily a limited number of staff. We also estimate on the case-related assumptions, or we assume that there would be some support available from respondent states by way of in-house counsel as well as local counsel. And finally, our final assumption on case-related assumptions is that the counsel team would only be working on counsel work and not on other possible support to states, which would include negotiations of agreements. So this brings me then to the estimate of the possible workload. And here I will report back on two major estimates. That's on mediation services and on arbitration services. Starting with mediation, as many of you will know, there have not been many investor state mediation cases, and those that there have been, the data is not available. So the approach that we used is one that we used throughout the process of this study, which is to consult as widely as possible with the largest number of stakeholders. And here we interviewed counsel, we interviewed mediators, as well as administration centers carrying out mediation services to get to our numbers. And here we saw or found that on average mediation cases took a shorter time than arbitration cases, and the time frame here is about half the time. So the result of our estimates is that we could have or be able to provide robust mediation services with two specialized lawyers. And with that, staffing would be able to have 4 to 6 mediations in a year. With respect to arbitration, we used two complementary methods. The first was a statistical method, and here we looked at available cases available reported cases, and looked at the lawyers' fees reported in those cases, and used that to estimate the workload of the arbitration lawyers. Our second method was an interviewing method, and again, like in the mediation case, we tried to interview as wide as a number of possible experts to get to our numbers. The results that we got were substantially the same. And here we saw that in the first case, with 13 lawyers focused on arbitration, we could have about 7 arbitration cases a year, possibly up to 8 or 9, but this does not include annulment or enforcement proceedings. Using the second method, we saw that 13 arbitration lawyers could handle about 8 cases. Some estimates were up to 9 cases, and indeed others were not more than 6 or 7 cases. So overall, our estimates based on the two scenarios, one in which we had 15 lawyers and a second in which we had 8 lawyers. Starting with the first is we would have 15 lawyers, including 3 secondees, 3 administrative staff, which would include paralegals. And here we estimate that we could have 4 to 6 mediation cases and up 7 to 9 arbitration cases concurrently. In the second scenario, we would have 8 lawyers, including 2 secondees, 2 admin staff. And in this scenario, we would have 2 to 3 mediation cases and up to 3 to 4 arbitration cases concurrently. I have run out of time. I fear my microphone will be switched off any minute now, but we can have any questions, which I'm sure you will have after this session. Thank you very much. And I hand over now to Nicola to speak on budgeting and financing.
Thank you very much. So the second part of our report is concerned with the possible budgets and then with the sources of financing. And again, we have made a number of assumptions that may be mentioned. Let me just mention one. We are not including a number of costs that are inherent in arbitration proceedings, such as institutional costs, administrative fees to be paid. We are not including the fees of the arbitrators, and nor are we including the costs of technical experts. Some of these costs may be high, but so the project is really about financing the attorney's work, which of course is of essential importance and undoubtedly the most important post in an overall budget regarding arbitration proceedings in investment treaty matters. Now, having said that, the starting point is that we have 2 basic estimates. The first one is for scenario 1, as mentioned by Ndanga before, which is with 15 lawyers and 3 administrative staff. And then we have, in that hypothesis, installation costs of $275,000 US, and recurring costs on a yearly basis of $3 million USD. In the second scenario, with 8 lawyers and 2 administrative staff, we have installation costs of $230,000 US and recurring yearly costs of $1.9 million. So basically, we are talking about a budget of between 2 million and 3.5 million in the first year, and then on a recurring basis between, say, 2 and 3 million. And with that budget, we can handle the number of cases mentioned by Danga. So that is the first point. The second point is that when we look for the financing, we have to consider a number of either constraints or objectives. A first basic requirement is that we need a start-up funding. We can't start from nothing. We will not have a number of incomes that may come in at a later stage, fees in case of victory in arbitration cases. We will not have them in the first year, and so we need a startup fund. Then, very importantly, funding must be stable. If the center takes up a case, it must be able to handle the case until the end, which may take several years. So that is a guarantee that the center must be able to give. Third, in more general terms, the funding must be so as to guarantee the autonomy of the center on a long-term basis. The lawyers must be able to work independently in the exclusive interest of the client, and therefore they must not be subject to uncertainties as to the financing of their activity in the year to come. And further, users must be implicated in the work of the lawyers. They must retain ownership, and inevitably this will be a scarce resource, so there must be some incentive for them to make use of the resource with wisdom in a reasonable manner, which means that there should be some kind of financial contribution on the part of the users. And then, of course, and this is the alpha and omega of the creation of the center, there must be an equitable system for the users. They must benefit from services, the best possible services, at the lowest possible rate. So these are our overall objectives. And as you can see immediately, this means that we need a combination of various types of sources, because some will serve the stability, others will serve equity, etc.
Nicolas, could you come to the end, please?
Already, okay, and therefore we have several kinds of resources. First, one-time membership fees, entrance fees, that will be different depending on the categories of states. Second, the fees charged for services rendered by the center, which again will differ depending on the categories of states concerned. And then recovery of costs in case of victory. And very importantly, inevitably, voluntary contributions, notably from public development aid, because it is clear that without some assistance from public aid, it will be very difficult to obtain a stable and sufficient income to render the services required. Thank you.
Thank you, Danga and Nicolas. Obviously, we will be discussing this subsequently. Let me just sort of summarize to point out perhaps the key issues. Under the scenario 1, we have 15 lawyers, including 2 for mediation and 3 secondees, and that's very important because of capacity building. And we estimate in light of our interviews that one could do an average of 5 mediation or 8 arbitration cases. And the budget would be roughly 3 million. So this is basically the scenario one we're working with. And it is oriented, as you know, very much on the basis of the WTO center. This is all just as was pointed out, an experiment in terms of thinking through what the costs are. Now let me turn to Charlie, if I may. Charlie, you have experience in ISDS cases. So what I wanted to ask you is, do you think that the estimate of the number of cases an advisory center on international investment law, given the number of staff posited, is in the ballpark?
Well, I'm here to provoke more than answer. So so I think my answer is this. I think in general the ballpark figure is right, but it's based on many assumptions. I think you're right that it's sort of semi-based on the ACWL model. That assumes to some extent that the cases, the WTO cases in general, they're more similar in nature than the ISDS cases, because ISDS cases, it can be a very wide range of issues. And obviously that takes more time. From my experience, from one ISDS case to another, it could be a different team or different expertise or technicality altogether. So that could take more time. My impression also of the estimate was that the number of lawyers I think it's right, in that normally, in my experience, you would require about 3 or 4 lawyers pretty much full-time on a particular case. But I think what's perhaps missing from the estimate is, from my experience, there might need to be more paralegals, just to back up the full-time lawyers, so that they don't have to spend so much time on the background work. And also another factor I think that's important is to what extent the state using the service can also provide in-house lawyers to support the external counsel lawyers. Because if you are, dealing with a country with a very strong team, then it will be a totally different question to a country with no experience at all. And also another factor, which I think has to come into play at some point, is the ability of the lawyers themselves. Obviously, if you start such a center, will you be able to get the top lawyers in who will require less time, perhaps, than the not so experienced lawyers and that sort of thing? Thanks, Carl. I think that's my provocation, and then I'll answer more questions as I come to it.
Thanks, Charlie. And yes, please do feel free to come back. Well, you said that the figure that Nicholas Ndanga gave us is a ballpark figure and sounds right. If that is the case, let me ask to Gaston. Do you think, what can an advisory center handle? What would be the implication for the work of the center if indeed the figures which we have gotten from Nicholas and Ndanga are in the ballpark? They have focused on just providing representation. What else could they handle with a staff like that?
Okay, can you hear me?
Yes.
Okay, thank you for giving me the floor. Yes, I think the scope of work of such a center is something very important, and the scope might be very wide, but this will also need a huge budget. So to avoid such a situation, that will give rise to some difficulties of raising money to finance this center. I think the center should focus on something which will be easy to be financed. And in this regard, you have mentioned representation. I do agree with such allegation. And also, I can add something like capacity building. So for the beginning, at least for the beginning, capacity building and representation seem to me actions that might be easily financed, at least for the beginning. And in this context, we should be very careful because the center should also be attractive from its financial point of view. Being dedicated primarily to underdeveloped countries, they should be interested even to finance at least somehow. So, to my humble opinion, the determination of the scope of work of the center is very important. And we should take into consideration the fact that the world is actually facing a financial crisis due to this COVID-19. So this is an element that we should not avoid to take into consideration because it could also appear as a constraint for those of the country interested that would be available to finance the center. So to summarize what I was saying, I think the center should focus on activities at the beginning that are easy to be financed. And I think representation and capacity building could be something for the beginning. Let me stop here, not to be interrupted. Thank you.
Thank you, Gaston. Very kind of you. Let's continue and let's turn to Natalia. Given what Gaston just said and Danga and Nicolas before, especially as far as the financing is concerned of these activities, representation and capacity building, the note identifies various sources of finance to get the center up and running. What do you think about them?
Sorry. Thank you, Carl, and thank you for all the researchers that did this note. It was very interesting to read. Costa Rica is still considering the overall idea of an advisory center as part of the reform options. However, we are glad to share some of our considerations on the issue of today's seminar. Certainly, one of the main hurdles that an advisory center could face relates to the sources of financing to begin and maintain operations. So allow me to share some general comments and then move on to the specific options. First, the search for financing should be preceded by a conceptual agreement on the objectives and core principles of the advisory center. For instance, questions such as which services will be rendered, categories of developing countries will have a priority for access, what will be the structure of the fees should be addressed beforehand. This will also allow countries to make informed decisions on whether to become members and therefore pay the membership fee. Transparency and accountability should be at the core of the operations of the advisory center, but also we have to take into account that these mechanisms may have costs. For instance, a web page in various languages, audits, etc. Third, there must be a very clear definition on the costs and the budget of the advisory center to establish appropriate membership fees and fees for the services. Also, fees should be affordable in order to encourage countries to form part of the advisory center. But what do we mean by affordable? How will the different levels of economic development of countries will be considered? Any financing scheme also needs to be defined for the operation of the center should pursue long-term autonomy, as the note correctly points out. Thus, several sources of financing will be necessary. And last but not least, in my general comments, the creation of the advisory center will occur in the aftermath of the COVID pandemic. Many countries have thinner budgets and their priorities lie on economic recovery. The creation of an advisory center will need to align with those priorities. With regards to the specific options, a one-time membership fee could provide the necessary funding to start operations. It will be necessary to determine an appropriate methodology considering elements such as different levels of economic development, the services to be offered, equitable access, and the staff required to meet demand. Participation is important for the success of the advisory center. At the same time, states have limited resources, thus justifying its importance will be essential to the discussion of membership fee in the membership fee structure. In the case of fees for the services rendered, a question to be addressed in detail is how to differentiate the rates for legal opinions, mediation, assistance in cooling off periods, representation in arbitration, and just advice, but no representation. So we do think that they merit different fees or hourly fees. Another issue to define is the possibility to charge higher fees to non-members. But what happens if such a country is one that is within the prioritized categories of countries? Voluntary contributions must be secured at least to have an initial fund and consider the average duration of a case, since no financing from fees for work performed will be available during the beginning of operations. So they will be absolutely necessary at the beginning. On this same funding option, and based on the case of the advisory center on WTO law, where the bulk of its budget is financed from voluntary contributions by states, it is important to think about the factors that will encourage states to channel their official development assistance to a future advisory center on investment law. So how do we prioritize the advisory center for these voluntary contributions? Another issue to bear in mind is avoiding conflict of interest with donors. Funding through recovery of costs by respondent states is a realistic option. However, it poses some challenges. On the one hand, fees charged by the advisory center will have to be affordable. On the other, fees have to be grounded to market prices. So when costs are awarded, they pay the real cost of the services rendered by the advisory center. Finally, having an ISDS user's fee can be a source of permanent funding. It might have the effect of spreading the cost among many stakeholders. Nevertheless, besides from the difficulties inherent to its architecture, it is important to consider if this can become a burden for small and medium enterprises or companies in distress. Another key consideration is the definition of user. For example, if an amicus is covered, it would inhibit the participation of NGOs or academic institutions which provide relevant perspectives to cases. We appreciate the opportunity to speak in the forum and welcome any comments and questions.
Thank you very much, Natalia. Very concrete, very much appreciated. And of course, it gives immediately the basis for Rebecca to comment. And maybe, Rebecca, you could start out by telling us what you think, realistically speaking. What could be the main sources of finance for an advisory center?
Well, thank you, Carl, for the opportunity to speak at this event. Well, first of all, the Netherlands recognized that an ASIL or another type of assistance mechanism can enhance the legitimacy and fairness of ISDS by strengthening the assistance to under-resourced developing countries, especially LDCs. And in this regard, the establishment of such an ASIL can be complementary to a multilateral investment court, being mindful of the prerequisite that these institutions should be independent from each other. To come to your question on specifically the financing, in the note it is mentioned that it would be desirable for the ASIL to be financed to a significant extent from sources that do not make an ASIL dependent on the renewal of voluntary contributions. And according to the note, it would be difficult to charge fees with a purpose of achieving break-even for the center. The largest part of the center's services is likely to be delivered to LDCs in lower, middle, and low-income developing countries. Taking this into account and coming to the essence of answering your question, what will be the main source of finance? According to us, it is quite likely that a significant part of the budget would be financed from contributions by third-party donors. And those donors may be private or public. As for the latter, it would be quite likely in the form of official development assistance. Having said that, a few notes from our perspective, the Netherlands being a potential donor country. Well, firstly, taking into account the complexities of the system, I would like to highlight a few aspects which should be carefully considered, also in the context of Working Group 3 discussions, of course. So who can contribute, if this would be just governments or also foundations or private donors? To what extent and to what they contribute to specific cases or to general funds. Thirdly, on what terms the financing takes place. So for example, to also obtain services in exchange, the right to participate in management meetings, or to receive reports on the work conducted. There are several examples that one could imagine. And lastly, the degree of transparency. As Natalia also has mentioned, there are a few tensions that could arise, and let me give you some 3 additional examples from our perspective. Well, firstly, it may be politically challenging for donor countries to support a fund that would ultimately be used by governments to defend claims brought by this country's outward investors. Related to this example, it may also be difficult for states to fund defense of claims that donor government stakeholders do not believe should be claims at all. Rather than strengthening support for international investment treaties, an ASIL could instead generate additional awareness and trigger criticism even. Lastly, donor countries may face political or policy difficulties supporting the defense of certain types of cases. For instance, the cases relating to direct nationalizations, there may be concerns about the use of public funds to support the defense of such conduct. To close, which also fits with what Gaston mentioned earlier, compared to financial support directed at litigation, the support of capacity building efforts has a direct link and less of a conflict with the country's outward investors' interests and could potentially be more easily supported. And such matters will, of course, have to be further explored in the context of Working Group 3 of UNCITRAL.
Thank you very much, Rebecca. Now we have a number of questions on the table, and there is also one in the chat box that perhaps Nicolas or Danga can answer. The question is, would the salary scale be sufficient to retain experienced international trade lawyers, given the lucrative remunerations in the private sector? I saw that, I don't have the gallery here, but I saw that Cherise Wallace from ACWL had registered. If Cherise is with us, Robert, do you think you could also let her in? Because obviously this is an issue where the ACWL has some experience. But first, Nicolas.
Thank you, Carl. I think that as concerns the wages, a good starting point, I think, is to consider that among the participants in this meeting, many are public officials, and all of them could probably earn better wages if they were in the private sector. So people choose the public sector for some reason, which is not merely about making more money. And basically, we believe that the arbitration community and the attorneys are a very large community, and there is little doubt that some people, in my view, some people would certainly be willing to work for this very stimulating, important project at a wage which would possibly be less than what they earn in the private sector, but which would still be I think, a quite attractive wage to do interesting work with interesting colleagues. Thank you.
Thank you, Nicholas. Cherise, since we got you on the screen now, same question to you, but can I also raise another question that Rebecca had raised, namely that it may be difficult for donor countries to provide money to an institution that then is helping the opponents of their claimants to win a case. I mean, in some sense, the same thing applies to your center, to the to the ACWL, because after all, you are in the same situation. So maybe you can comment whether that has been a problem in terms of your work. Cherise, please.
Thank you very much, Carl. And thank you to all the presenters and discussion starters. It's very interesting that a lot are actually ACWL members. So it's very interesting to see their contributions. With respect to the first question about the remuneration, perhaps I can best answer that by referring to the actual facts. Out of the 12 lawyers that we currently have at the ACWL, 3 have come from law firms. One was a partner, one was an associate, and one was of counsel. So these people made an active decision to leave their law firms to come and join the ACWL. I think there are, many benefits working at the ACWL, as there would be for an advisory center on international investment law. I think the issues are very interesting. You get to focus on substance and you don't have to worry about billables. That's one part. With respect to the second question, the point that Rebecca made, I think that's a very valid point. And it is something that we had discussed at the ACWL. Now, given the patterns of trade, it is sometimes unlikely that some of our developing countries or LDCs would bring a dispute against some of our donor countries directly. We have the bulk of our donor countries are members of the European Union, and therefore, any case that would be brought against the European Union, which is not in and of itself a donor member to the ACWL. But we have had an instance in the past of where we did bring a case against a donor country, and it was quite a complicated and sensitive case. And that donor country continued to support the ACWL throughout the proceedings and has continued to support us after those proceedings. So I think that goes to the issue of the contribution that is being made to the multilateral trading system to ensure that developing countries and least developed countries have a voice, have representation. And I think the donor countries, we call them enlightened donor countries, make that decision to contribute, even though there is a possibility, and in one case, an actual incident of a case being brought against them. Thank you. I will conclude there.
Thank you, Cherise. Very helpful. We have another question in the chat box, and maybe Danga or Nicholas can respond to that. What would be the monitoring and evaluation mechanism for the center? Annual reports for the members, question mark. We didn't, I think, really go into these issues because as also Rebecca indicated, there are quite a number of issues, and Natalia indicated there are quite a number of issues that obviously need to be resolved, I think we focus very narrowly on the question of financing and sources of finance. But if Ndanga or Nicholas has a comment, please feel free to go ahead.
Nothing really to add to that. I was just going to say that we didn't focus at all on the governance of the center, and that in itself would be a topic that would, of course, need much more detailed discussion on which would relate to membership, relate to sources of funding, going on to other factors such as management of human resources and all those other important elements. We didn't go into that at this stage.
Thank you.
I would, if I may.
Please.
Thank you. I would perhaps add that from the perspective of reporting or monitoring, from our perspective, being the financial perspective, I don't know what the mechanism would be, but the objective of any monitoring should certainly be first to maintain financial security over time, so as to make sure that the center can handle the cases it has taken up, often a few years before, well, for a few years. And then the second one would be to maintain, to avoid conflicts of interest in financing. So I think these are two elements that are of essential importance. One, stability, and second, autonomy and integrity, say.
Thank you.
May I add something concerning the financing? Some few words.
Please.
Yeah, you see, I was quite interested with what Cherise has said concerning one of the donors. And from what she said, I want to stress that the center must be and remain independent. Therefore, the sources of financing should be very carefully determined, because if a donor is able to have a great influence on the center, I think this might be very, very dangerous for the parties or even for the beneficiaries of the state that are being assisted by the center. Therefore, we should be very careful when accepting as financing something from even public or private sectors. So the independence of the center, which seems to me something as important as its stability and integrity. These are the qualities that must be those we easily find at the center. If not, it will be very difficult for it to be attractive, because I speak from an underdeveloped country, and it is very sensitive, a situation where a state can have the impression that the center is not independent. That will be a great constraint for its, you see, for its, how can I say it?
Credibility.
The word.
Its credibility.
For its, yes, for its viability.
Yeah.
And
it's quite clear.
Sorry, Carl?
Credibility, as you.
Exactly, that was the word. Yeah. It will be very, very counterproductive for its credibility. So it's a very important point we should take into consideration, the independence of the center. And that's what I think I can add here. Thank you.
Thank you. And this is, of course, part of what Ndanga said as far as governance is concerned. And it's a broader issue that obviously needs to be addressed. And we did not address in the context of this paper. I wanted to, because we're getting towards the end, I wanted to see whether André von Walter or Colin Brown are on the call. Robert, if they are, can you let them in, please, or upgrade them, please?
Yes, Colin is being promoted right now. He should be on momentarily.
Congratulations, Colin, to your promotion, and Andre as well. Both Natalia spoke about voluntary contributions. Natalia said they would be absolutely necessary, and Rebecca also referred to ODA. And of course, if we think about that, we think about, at least I think about, the European Commission. What do you think are the possibilities or chances that if an advisory center is established, or were to be established, that this is something that could attract ODA, more or less similar to ACWL? Colin, I see your picture, so maybe you can speak, please.
Yes, hello to everybody. I wasn't expecting to be given the floor there. So it's one of the surprises of these types of
life.
So I think we're at a stage which is fairly early in this process. In the sense that we've had a discussion in the working group, which has shown a high degree of interest in the notion of an advisory centre. It is something obviously which has the broad support of the European Union and its member states, and I think, you know, we would need to see further progress, both through the process here that you're managing, but also then discussions in the working group and around the working group itself, so that we start to move forward. And I think a number of the issues that will be important in terms of the union's ability to provide financing are the kind of the types of issues that we've been discussing. So parts of the issues around scope, but also very importantly issues around governance and structure. So I think it's a bit too early to say yes, the Commission will necessarily be able to provide financial support, but I think we're very clear in supporting broadly the initiative, and I think the more we can progress on this, and I think this is something that we would like to see happening as soon as, or as much as reasonably possible, the more we can progress on this, the more we can get to the point where the Commission can start to try to make concrete decisions on this. So I think that's what I can say at this moment in time. Thank you.
Thanks a lot, Colin. We're coming to the end of our hour, 5 minutes left. I want to conclude by asking a final question to every one of the panelists, to be answered, please, in one sentence. Namely, what do you think is the single most important thing as far as cost and financing are concerned, moving forward? And as I said, one sentence ideally, and then the last word is to Don to, if he feels, to answer the question too and to conclude. Why don't we start with Rebecca?
I will keep it even shorter. Transparency.
Okay, very good. Thank you.
Sensitization. Sensitization of states.
Say it again.
I said sensitization of the state.
Okay. Natalia?
I would say how to start operations. Well, you can get some money from, or some returns from cases defended.
Good. Charlie?
I think for me, it's discussion among states. It would be very difficult to start without proper discussion on solid ground for this center.
So you're pleading for more webinars, given circumstances. Nicolas?
Better explain to donor states, potential donor states, I'm thinking about the Netherlands, that this is really about the legitimacy of ISDS, and therefore it's about convincing developing countries that they still have an interest in accepting the system and that it is fair towards them.
And Danga?
I would say thinking through the scope of services and beneficiaries. And in the first part, and I'm cheating more than one sentence, but in the first part, really ensuring that we have a robust mechanism for amicable settlement and mediation before getting to very expensive arbitration.
These were not two sentences because it was a semicolon between them. So you're okay. Don, for your final observation and concluding the webinar, please.
Well, I want to thank everyone very much for a very full discussion. As we know, there are many aspects of this subject. On this matter of finance, the sources, the legitimacy, stability, the amounts and the stability. And I think one final point I would make goes beyond the center. I think it was intimated by Anna. This question of finding the money is going to apply to other aspects of the Working Group 3 reform project. And I think we should begin thinking about that sooner rather than later, so we won't be surprised. But again, I want to thank everyone, Anna, Carl in particular, the indispensable, indefatigable Carl, Nicholas, of course, and Ndanga, and everyone else. So thank you very much for this. I think this has been a very good program, and I look forward to the French and possibly the Spanish or even other versions of this discussion. Thank you very much.
Thank you very much.
Thank you, everybody, and thank you also to those who have posted comments in the chat box. There is still one from George Berman, and also another one, which perhaps we can take up in the French version. So thank you very much to everybody, and thanks again for Robert for getting us flawlessly through this exercise.
Thank you. It's our pleasure. Okay, thank you.
Bye. Thank you very much.
Okay.